running. I ought to perhaps say, first of all, I'm the chairman and leader of the English Democrats. We're a party that's still, I think, a lot smaller than UKIP is. Our main difference from UKIP is obviously we're focused on England and Englishness and English identity rather than on Britishness. But it is the English Democrats that are bringing the case. And the case is against, as the grounds of the application say, the Prime Minister and the Secretary of State for exiting the European Union. Let me explain what the case is basically about. It's actually quite a simple point, really, in a way, which is we served a notice, a 2-year notice, and our notice expired. And it's a basic sort of legal proposition that when you've got a notice and it expires, at that point, whatever it is that you're served the notice for, like for instance if you're leaving your employment or you want to get out of a lease or something like that, when the notice expires, you're out. The employer can't tell you to come in to work the next day. The landlord can't insist that you pay more rent after your notice is expired. So the only legal questions around notice is, was it properly served? Was the procedure at the beginning of serving it the correct one? And also, whether there are any reasons at the end which take us out of the normal thing happening. And you might remember, I'm sure everybody wants to sort of boo and hiss a bit, but you might remember Gina Miller's first case. Yes, yeah, well done.
It's still going on, isn't it?
Well, she's trying another one. She really, if this case it succeeds, is going to deserve to be thanked, and of course she'll be sick as a parrot if she is thanked for it, because what she did was she got 2 things established in the court system in a way that's really clear. Because the courts work on what's called precedent, which is basically that the judges give a detailed ruling. And in Gina Miller's case, what happened was it went all the way up to the Supreme Court. And so only about 3 years ago, we have got the most authoritative ruling that the English court system can possibly provide. And that ruling had 2 important consequences. One was that the government was told that in order to serve this notice, it had to have an Act of Parliament. And so what happened was, as a result of that they passed that Act of Parliament. You might remember there was a sort of one of those moments in parliamentary history where everybody gives a show of unity, and virtually all MPs went off and voted in favour of what's now the EU Notification of Withdrawal Act 2017. Now, I'm sorry, the names of the acts are terrible. You're bound to confuse lawyers, everybody. But it's the key act to bear in mind is the 2017 Act, the EU Notification of Withdrawal Act. That is 137 words. It's dead simple. Anybody can see if you look at it. That all it does is it authorises the Prime Minister to serve a notice for the purpose of withdrawing the UK from the EU. That's it. No other power, nothing else. So she then serves that notice, and it expires on the 29th of March this year, 2 years, because the notice is served under the other thing that we need to spend some time thinking about, which is Article 50. Article 50 basically says that the procedure for serving notice has to be under our constitutional arrangements. And since that notice was served, there's been another court case, which is the Whiteman court case, which you might remember the SNP make a great fuss about taking the UK government to the European Court of Justice, which is the EU court, and they got a ruling on whether or not the Article 50 notice could be revoked. And there isn't anything in Article 50 to say about there being a power to revoke, but the European Court of Justice said that there was a power to revoke. It was a sort of implied power in any notice you can revoke, which one can sort of live with as an idea. But the interesting thing is that they also said that even any decision to revoke would have to be taken in accordance with our constitutional arrangements. So basically, what they've said is confirmed is that all parts of Article 50 are subject to our constitutional arrangements. So we were quite keen to find an argument that didn't involve trying to interpret Article 50. Because the trouble is, if you're interpreting Article 50, you're probably going to wind up before the European Court of Justice. And the European Court of Justice more or less outright said in the White case that they will always look for the answer that promotes the federalist agenda. So they are openly political in their judicial decision making, so that's part of the reason why we were focusing on the notice period in this court case. The other thing is about the notice period is what you then get into is that if the notice has actually expired and there's no reason why you could possibly say that it didn't take effect legally, then we're actually out already. And so there's quite a simple thing that the court can do, and it can declare that we're out. And then obviously all aspects of government have to accept that that's the case. Whereas if you get into a slightly more complicated argument about whether or not the various aspects are voidable, is the lawyer's expression, you then hit the question that the court might say, well, it's up to the court to decide whether we're out or not. So we've tried to avoid that. But let me just read you a couple of bits of what I've been talking about. So, first of all, Article 50. The key expression that I was mentioning. 1, Article 50, paragraph 1. Any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. That's the key bit. 2, a member state which decides to withdraw shall notify the European Council of its intention. There's then about negotiations. And 3, the treaties shall cease to apply to the state in question from the date of entry into force of the withdrawal agreement, or failing that, 2 years after notification referred to in paragraph 2. And then we come to one of the unlesses as to whether or not it might still be in, arguably, unless the European Council, in agreement with the member state concerned, unanimously decides to extend this period. Because I said that there were really sort of 2 sides that you had to look at with the notice. The first side is whether or not it's properly served. There's a proper mechanism employed. I don't think there's any possibility of anybody arguing that it wasn't done correctly, because they followed the Gina Miller ruling, they got the Act, and let me just read the Act, 2017 Act, EU Notification Withdrawal Act. 1. Power to notify withdrawal from the EU. The Prime Minister may notify under Article 52 of the Act of the European Union the United Kingdom's intention to withdraw from the EU. That's it. And it says in the preamble that it's an act to confer power on the Prime Minister to notify under Article 50.2 of the EU, of the Treaty on the European Union, the United Kingdom's intention to withdraw from the EU. There's nothing more there. There's a second paragraph which says the treaty has effect, this section has effect despite any provision made by or under the European Communities Act 1972 or any other enactment. So it's clearly was properly notified. And then, at the end of the notice period, I was thinking as we came up towards it, we were getting more and more row going on in Parliament. And it seemed to me that Theresa May wasn't playing straight. So, back in February, I wrote to the government. I did what's required under the civil procedure rules to start the ball rolling. And I wrote a protocol letter on the 28th of February, basically saying that if they thought that there needed to be an extension, amongst other things, that they'd need to get an Act of Parliament. And by the way, when we talk about Gina Miller, I'd like to know there is actually film of her about 6 months, well, about 8 months ago now, saying that if there wasn't a new Act of Parliament, she thought we'd be out.
She will what, sorry? She will what?
She thought we'd be out.
Oh.
So she was agreeing with what we're trying to say in this case, in other words. Although now she makes out that that isn't her position, but then I understand she's got sound financial reasons for thinking that way, with large donations from George Soros, amongst others.
So, are you going to try and
Possibly. But may not need it if she's got a large enough subsidy from Soros. So I started the ball rolling before we actually got to the next point, which was Theresa May saying that actually she wasn't going to. We weren't actually going to go out, despite her, what was it, 108 times that she told Parliament that we were out on the 29th of March. The government actually wrote back to me saying that they had no intention of revoking or extending. But of course, shortly afterwards, they then extended, or purported to extend, I should say. And I immediately wrote saying, needed an Act of Parliament. All this was done before the 29th of March. On, I think, the 28th of March, they got a statutory instrument through under another snappily named Act, the EU Withdrawal Act 2018. And the statutory instrument said that it was changing the definition of exit day in that Act to, from the 29th of March to a couple of dates, one in April, I think the other one was May, wasn't it, originally? But then there's been another Act since, the Cooper-Ledwin Act, which is the reason why we've been another extension. So the government's comes back, having agreed that they are going to extend the period of time we're in. And Theresa May says, first of all, she's got a prerogative power. Because I want to come back to dear Gina Miller again, because Gina Miller's other good point in her case was that if there's an Act of Parliament in play in an area, then there's no royal prerogative. Because the royal prerogative is a sort of fill in the gaps type of idea. But if you've got an Act, then there aren't any gaps as far as the law is concerned, and the minister has to behave in accordance with what the Act says. And I might remind you, I've just read out, we've got an Act, the EU Notification Withdrawal Act, which only gives her power to serve a notice withdrawing us from the EU. It doesn't give her any power to extend the period of time, or to negotiate for more time, or to agree more time. She can't either ask for more time as a minister, or agree it under the EU Notification Withdrawal Act 2017. So she says prerogative, and my answer to her saying prerogative is Gina Miller. Gina Miller's case says there can't be prerogative in that situation. It's really as straightforward as that. The second thing that the government claimed was it was something to do with international law or EU law. Well, no. The EU law is very clear. Article 50 says it's under our constitutional arrangements. The third possibility that the government has come up with, and we've had their detailed grounds of resistance. The third argument they've come up with is that they were able to extend the period of time by changing the definition of exit day. That's a bit more of a complicated thing to deal with. But the first point is the statutory instruments that can be produced under an Act have to be about the subject matter of that Act. In other words, they have to be within the bounds of that Act. The EU Withdrawal Act 2018 is only about transitional arrangements. It's not about when we go. And that's quite important, because what that means is that it would be ultra vires, it would be beyond the bounds of that particular Act for the statutory instrument to be extending or defining the date we actually left. The reason that they put that provision in to be able to change the date wasn't actually about extending the time we were in. What it was to try and make sure that the transitional arrangements came into force when they'd done their withdrawal agreement. So they could do the withdrawal agreement, they get that from Parliament. That wouldn't necessarily kick in on the same day as our notice expired. And in fact, after all, as I read out earlier, the Article 50 notice, Article 50, talks particularly in terms of when the notice expires. It expires, the treaties shall cease to apply to the state in question from the date of entry into force of the withdrawal agreement. So the reason for being able to change the exit date was to implement on the day that the withdrawal agreement came in. That was the point of it. But then they're trying to use it for something completely different, which is to keep us in. And there are a couple of other sort of technical reasons why it can't possibly work as an argument in law. One of which is that this is called a Henry VIII provision clause, and the courts and the system have long since developed all sorts of ways in which they curb Henry VIII's powers. And one of them is there can't be any sort of discretion involved. So when they gave 2 dates that it was going for, that was automatically a breach of the provisions of whether or not this clause could actually be legally valid. And there are a number of other points. My counsel, in enthusiastically arguing the technical points, has produced a detailed submissions which run to 25 pages, which I'm pretty sure you don't want me to go into all of that. So, procedurally, we'd started the ball rolling before the 29th of March. On the 29th of March, I finished off drafting all the necessary paperwork. I made sure that the unissued paperwork was served on the government on the morning of the 1st of April. And the appropriate time for it, given what they're up to. I then went along into the Administrative Court in the Royal Court of Justice, got the papers issued on the 2nd, went round and personally served government's lawyers on the 2nd in the morning. They gave us their detailed arguments against what we had said, those 3 points. But on the 17th of April, just before Easter, the guy who drafted their points is Sir James Eadie, who was the QC that they used with Gina Miller. He's given to going right over the top with what he says, because in her case he said that it wouldn't only be wrong to give her what she was asking for, it would be unconstitutional for the court to even consider it, which obviously didn't work terribly well, did it? But he still got a knighthood out of it, and quite a lot of money from what we gather, because the Freedom of Information Act request under the in the Grimes case, which showed that he'd been paid over £8 million over the last 10 years. Yes, indeed.
From whom?
What?
By the government.
By the government?
By the government, yeah.
Or the EU, or?
Well, that's only the government's payments to him. He may have had other payments.
To do their bidding?
Yes. So we'd had their defence, as it were, let's call it that. And we then put in arguments against that, saying why that was wrong. And then basically we then had a long gap. And during that time I had applied to expedite the case twice and heard nothing. I then went away on holiday for 2 weeks, and my passport was obviously went over a scanner. On the Tuesday afterwards, was then an order basically making it so that unless we get our appeal in within, in effect, 9 days, when I'm on holiday, the case will be struck out altogether. No possibility of bringing it back. So some people say that could be just coincidence. I have to say I've got grave doubts, particularly when the department, of course, in question is run or headed by David Gork, who's an absolute Romaniac. Anyway, so we managed to avoid that particular one, because although I'm a sole practitioner, I didn't do what most sole practitioners do, which is shut my doors and just go off and see what's in the mail when I get back. I had actually got somebody opening my mail, and by the way, they said that they'd posted this order to me, and normally in the High Court they email it to you, they don't post it. In fact, the previous order they had emailed it to me. So in this case they posted it to me, but they said they posted it on Wednesday, first class. Well, that can't be true, because all my post was opened on the Friday, and it hadn't arrived. And I'm only more or less the equivalent the other side of London to where we are here. So normally a first class post from central London would get to me the next day. Worst case, except at Christmas, it would be the day after, which was the Thursday. You know. Well, it was Friday. So I mean, I don't think they posted it on that day, which I do think that sort of adds towards the argument that they tried to trap us.
So, did you keep the envelope?
Yeah, we can't tell them, right? It's got a printed stamp on it.
It's franked,
But
right?
they wouldn't
No.
wanna-
It should
they-
surely be franked and hope
Now,
that it's even...
the official letters aren't franked anymore. What they've done is they print on. They've got a mass block printing of envelopes, and it just says it's first class. There's no date on it. It's one of the things we did look at, yeah. But actually, to be honest, even if we were able to prove that it hadn't been posted on that day, it wouldn't have made any difference. We would still have been having to apply to the Court of Appeal for permission to do so out of time when the official documents looked as if we were barred from bringing a
Should
case.
the document of that gravity be sent recorded?
Well, it doesn't matter whether it should or not. That's what they were doing.
But
And
the counter
the post office always offer you or ask you, do you want the proof of posting?
Yeah, but the courts and government generally don't do that. But anyway, we got the appeal in, and basically we've done everything we need to do. We're now sort of back in a way to where we were a couple of months or so ago. But the difference is that the judge that will look at it this time is a Lord Justice of Appeal, and I have found over recent years that you're quite likely to get a fairly sort of political judgment from a High Court judge. If you're trying to stand up for something that they're not likely to support, you've got to bear in mind that to become a judge these days, you've got to satisfy the Judicial Appointments Commission that you have a lifetime's commitment to equality and diversity.
Oh, great.
If you haven't got a lifetime's commitment to equality and diversity, you can't become a judge. And so all the lower levels of the judiciary are all multiculturalist Remainers, basically. You've got a chance of getting somebody who's going to be a bit more independent when you get to the level of the Court of Appeal. And I have found in cases that I've done over the years that when you get to the Court of Appeal, you're much more likely to get a decision that's purely according to law. And the two barristers that we've got, so-called junior barristers we've got, and the QC, who's done the skeleton argument for the appeal, all think that if we get a decision according to law, we should win it. It's as simple as that. It's only, is politics going to get in the way, or possibly is politics going to help? Because it has been suggested that possibly Boris might find it convenient, shall we say, that there's a decision that lets him off the hook, gets us out, and can't be tampered with by Parliament, which also any blowback, it's Theresa May's fault.
Does he know about you?
What?
Does he know about you?
Oh, yeah.
Yeah.
He
You
doesn't
made
know
yourself known to him, haven't
I don't know him personally, but I have spoken to people within his circle, and they do know about the
you?
case.
Has he offered any support or no?
But you wouldn't expect him to at this point, would you?
Without being
Because
pertinent.
if, for instance, if that got out on the internet and some lefty saw it, they're going to be saying, Boris is going to bring the house down.
Without being impersonate, because I don't know much about you, can you tell me what your qualifications are? Are you an international lawyer?
I'm a solicitor.
You're a solicitor. But obviously you've got some knowledge of EU law. Have you?
I have.
Yeah.
Yes.
Yeah.
But you can't become a solicitor without having some knowledge of EU law.
Oh, right. Are you the only solicitor that's doing this?
Well, yes, I think I am.
It's a bit strange, isn't it?
Well, most solicitors act for clients, of course.
That's
It's
true.
just
So you do it with
I'm acting for a client, which is the English Democrats, but obviously, as chairman, I was able to assist the client in making a decision. So that's basically where we are at the moment. I did print off some of the papers that are relevant to that, but I would just say, if anybody that doesn't see these, I have posted up on my blog, which is robintilbrook.blogspot.co.uk, have posted up every single document except one that I printed off here, which will be shortly going up, which is the skeleton argument on the appeal from the QC. And that's only because we've only just served it. You wouldn't put up something on a public blog until you've actually served it.
So just to be,
Happy to take questions.
Robin's sit down, so he'll take questions from the audience. But I know a lot of you have asked me if we can donate to your court case, and we'd like to. So I'm going to send this round, put in whatever you want.